Hello, everyone, and welcome to another CLE brought to you by the Global Law Alliance for Animals and the Environment and the Center for Animal Law Studies at Lewis and Clark Law School. Our topic today is problems in fisheries and the fisheries trade. And I'm joined today, as always, by Erica Lyman, Clinical Professor of Law and Director of the Global Law Alliance for Animals and the Environment. My name is Nick Fromherz. I'm an adjunct professor, senior attorney, and the Latin American Program Director for the Global Law Alliance for Animals and the Environment. And with that introduction, we'll go ahead and dive in. So we have a few objectives or topics that we'd like to work through today, and they all relate to one another, as hopefully will be clear. So first, we want to give the audience a basic understanding of the scale and character of IUU fishing. IUU fishing stands for illegal, unreported, and unregulated fishing, and we want to break down that term and also give a sense, again, of the scale. How big of a problem is it? Next, we'll start to look at different state actors to begin with in the fight against IUU fishing or the effort to control IUU fishing. So first, we'll start to look at flag states, then we'll look at coastal states. Then we'll move from the state realm to the realm of international organizations. And in this case, we're talking about regional fisheries management organizations, or RFMOs. We'll explain what those are for those who are not familiar. Then we'll look at market-based measures, and Professor Lyman will detail an example from the United States, the U.S. High Seas Drift Net Moratorium Protection Act, which leverages market-based measures to try to fight IUU fishing and some other related fishing harms. Next, we'll look at the role of port states. And this is something of a new trend, or at least there's been some very noteworthy developments in recent years on the port state front. So, going to our first substantive topic, let's talk about the scale and character of IUU fishing. And I want to just make a few kind of high-level points, but these are contextual points that we have in mind when we get down into sort of the more legal characteristics of what we're talking about. We want to get out the facts, right? What is the nature of this problem? So first, we want to understand that this is a very lucrative phenomenon. Here, you can see a graphic on your right, which shows revenues associated with IUU fishing, in addition to several other criminal industries, if you will. And we can see the olive shaded circles are what we might call environmental crimes. We have things like illegal logging and trafficking, clocking it at $100 billion estimated revenue per year. IUU fishing, the figure that's normally used is $23 to $30 billion per year. So that's a very big industry with a lot of money. And you can see, compared to the sort of non-environmental crimes, things that we more historically think of when we think of transnational organized crime, drugs, e-crimes, arms trafficking, IUU fishing, is right up there with them, right? It's in the same ballpark, right? The next point is that IUU fishing is complex and varied, and this is a critical point, which may seem obvious, but a lot of people overlook it. Yes, we have transnational organized crime involved in IUU fishing. Sophisticated organizations, lots of people involved, all of that. But also IUU fishing, as we'll see when we break down the definition, is going to include some offenses or some activities that might be considered relatively minor, oversights in the artisanal sector. So it's not all big, sophisticated transnational organized crime. Speaking of transnational, it is frequently transnational. Not always. As we'll see with the definition of IUU fishing, you can have, entirely domestic and even sort of, very, very localized IUU fishing activity. But a lot of it is transnational, especially when we get into higher value fish and larger supply chains. Another key point here, which really makes IU fishing, I think, different than a lot of other forms, or at least some forms of wildlife trafficking, is that we've got legal fishing and trade sitting alongside illegal fishing and trade. And yes, that happens with other forms of the wildlife trade and wildlife trafficking. But in the case of IU fishing, many of the items, the specimens, the animals, if you will, are in fact completely legal, right? So being able to, as you can kind of see on the graphic there, distinguish, okay, the legal fish from the illegally sourced fish or the IUU sourced fish can be very difficult, because it's not like just looking at the fish, I know, right? It's, you know, maybe a certain species of tuna, which is very, very present in legal trade as well. So it just makes it more complicated. As all trade, IU fishing responds to market laws of supply and demand. We just have to keep that in mind, right? People are buying these products. That's why this happens. It often flows from global south to global north. Again, many exceptions, but we'll look at a couple of maps which will demonstrate that there's some major IU fishing problems in the global south, and a lot of those fish do end up going to the bigger markets in the north, in Europe, United States, big Asian markets, etc. And continuing on then, with those kind of facts in place, let's move to the law. And the place to start here is really international law of the sea, and within international law of the sea, it's kind of fisheries components. So that's our place to start. Now, when we talk about international law of the sea and the fisheries components within international law of the sea, the place to start is the UN Convention on the Law of the Sea, UNCLOS, as it's sometimes abbreviated. UNCLOS is often called the Constitution of the Oceans. And the basic idea is, like our own Constitution, it establishes a high level, but nevertheless critical framework. So it really gives us the rules of the road, leaving gaps, yes, to be filled in with other instruments, but nevertheless establishing kind of the basic framework. So UNCLOS establishes these rules of the road, or rules of the ocean, through a pair of related dimensions. First, we have a geographic dimension, and then next we have a jurisdictional dimension, and the two articulate with one another. So we have a little graphic here, and I apologize, it's in Spanish. We use this same presentation sometimes with Spanish-speaking audiences, but the images are more important than the text, and we'll break them down. Basically, here we have land, which belongs to the coastal state, and then we have 200 nautical miles of ocean. That 200 nautical miles of ocean includes the exclusive economic zone and the territorial sea. And basically, I'm generalizing a little bit here, but basically the coastal state, right? The coastal state is the one that establishes the key rules in that area out to 200 nautical miles on fisheries. What can be caught, who can fish, right? So administering licenses, registrations, establishing gear prohibitions, protected species, no-take zones, seasonal limitations, all of the different rules and regulations we associate with fisheries management. Now, beyond the 200 nautical mile zone, the game changes, right? It changes pretty radically, because out there, called the high seas, or sometimes called international waters, we don't have a state actor that can claim sovereign rights to the living marine resources. That's the term that's used in UNCLOS. Instead, it's international waters. Now, the actor that sort of establishes the rules of fishing, right? What can be fished, to what extent, et cetera, are international organizations known as regional fisheries management organizations. And basically, they are made up of states that have an interest in that fishery in that zone. RFMOs is the abbreviation. Now, the last bit here to keep in mind is, regardless of where the fishing takes place, there's another actor, or potentially another actor. And that is whether the fishing takes place in the EEZ of a coastal state or it takes place in the high seas, the flag state has duties nonetheless. The flag state always has duties to make sure that its vessel is respecting the law in question. So we'll talk more about the role of flag states here in a minute, but so far this is the basic picture. It's multidimensional and there are different actors involved here. Okay, continuing on. Let's break down this term a little bit. I'm going to try to do it quickly. IUU fishing. And we can just follow the letters. So what is IUU fishing? Well, let's start with the I for illegal. Some of this is common sense and some of it's not so common sense. So let's use a map to break this down. In this case, we have a map of the sort of northwestern part of South America, Peru, Ecuador, Colombia. We have national waters designated, and we have international waters designated through the lightest blue shading. So we're just using this as an example. So illegal fishing can take place in a couple of different forms, generally speaking, one of these two categories. First, it can take place within national waters. So in this case, we've got a little boat. It's flagged to Ecuador in this case, and maybe this vessel is fishing without permission of Peru within Peruvian waters. That's just one example. There are countless permutations, but the basic idea is illegal fishing includes illegal fishing within national waters of a given state in violation of that state's law, right? So it could be a Peruvian vessel, fishing without a license, using prohibited gear. It could be a vessel flagged to another state, breaking any one of a number of regulations. The point is, okay, this category or this broad permutation is national waters. We also have illegal fishing in international waters. Here's where it gets a little bit trickier. The international waters version is when a vessel flagged to a state that is party to an RFMO managing a certain fishery fishes in violation of that RFMO's conservation and management measures or other rules. So here, using Ecuador, that part of the ocean, assuming that this vessel is fishing for tuna or tuna-like species, that part of the ocean is governed, the tuna fishery is, by the Inter-American Tropical Tuna Commission. Ecuador is a party to that RFMO. That's very critical. Because Ecuador is a party, if that vessel is fishing in violation of the RFMO rules, then that's also illegal fishing, right? Because Ecuador is bound to that. Its vessel is not playing by the rules. That's illegal fishing in international waters. Okay, U for unreported fishing. This one's quicker, easier. Again, we can have our national waters variety. A boat says, hey, we've just fished, X amount of anchovies, when in reality, the boat has fished X plus 1,000, right? Anchovies. Well, that's unreported fishing. Now you might say, well, wait, but they've reported, at least my bubble says, oh, they're reporting a few anchovies, but they've underreported. And unreported fishing includes underreporting. And the basic idea is for fisheries management to work and to be, managed in a way that doesn't just crash populations, you need solid data on catch, and you set quotas based upon that. If you don't really know how much is being taken out due to unreporting or underreporting, you're going to get it all wrong. You're going to contribute to overfishing. We have our international version as well. Let's imagine a vessel, in this case, flagged to a state, that's a party to RFMO in question, and there are certain reporting requirements, but the vessel doesn't follow those requirements, underreports, misreports. In this case, they failed to report certain shark catch that the RFMO says they need to report. Again, that's unreported fishing. And here we see national waters, international waters, right? That's kind of a trend or a theme. Okay, finally, we have our last U for unregulated fishing. This one we like to think of, I think it's best understood as fishing beyond the pale or reach of the law. So this can actually come in three main varieties. First, you can have fishing, and I should say all of this, almost always is in the high seas. Because if it occurs in national waters, that's almost always at some level regulated, right? In the sense that you've got a state that has authority over fishing activity on those waters. So, okay, first we could have a stateless vessel, right? It's just not registered to a state, and it's fishing without the legal oversight, right, of a country. Well, that's unregulated fishing. Vessels are supposed to be regulated. Excuse me, supposed to be registered to a country. Next, you could have a flagged vessel, in this case, a vessel flagged to Argentina, fishing in the IATTC zone for tuna. Now you might say, well, wait, it's got a flag, that's regulated, right? Well, to some extent, the vessel is there's oversight, but Argentina is not a party to that RFMO in question. So it's unregulated vis-a-vis the RFMO. Finally, you can have a case where a vessel is flagged to a party and it's fishing, geographically in a zone covered by an RFMO to which that state is a party. So in this case, South Korea is a party to the IATTC. But if this vessel says, hey, we're not fishing for tuna, we're only fishing for small pelagic fish, then that's unregulated fishing because it's beyond the purview of the RFMO. Even though South Korea is a party to that RFMO, it's beyond the purview of that RFMO. So those are kind of our three basic categories or our terms, IUU, and our various permutations within those. And just as a footnote, I should say, we've been working here from the 2001 FAO International Plan of Action on IUU fishing. That's a soft law instrument. And the term IUU will be used in different ways in national legislation sometimes, and also in RFMOs. So there is some variety there. Okay, let's then look at flag states, because maybe flag states, are really the solution to IUU fishing. Because after all, as we've explained, flag states sort of stand as this backstop of authority. And if that's the case, then we just have to get flag states to police their vessels more effectively. At least that's one take on the issue, right? If flag states do their job, then IUU fishing goes away. And there's something to that, absolutely. We need to ask more of flag states. But this is easier said than done for a couple of reasons. One reason is if we think about major fishing nations, a lot of these nations have large distant water fleets. And what we mean by that is they're fishing way outside of their EEZs. They're either fishing in the high seas and or, fishing with or without permission in the EEZs of other states. So because the activity is so far away from the flag state itself, there is kind of a disconnect, and it's sort of a little bit of out of sight and out of mind, right? It's not sort of, the impact is not necessarily felt on fish living close to home. That's one part of it. And there are more explanations to the problem than what we're highlighting here. Another big problem is what's known as flags of convenience. So basically, flags of convenience are open registries. And what we mean by that is they are countries that allow a vessel to be flagged, to fly the flag of that country in exchange for a fee, without requiring any kind of real nexus to that state. So the vessel never has to go there. It doesn't have to have, a home port in that country. The owner doesn't have to, have a presence in the country. right? It's really the only connection is the flag itself. And the problem is these flags of convenience are associated with really, really low oversight and lax enforcement. Now, this table you see in front of you shows some percentages. This actually isn't just fishing vessels. This is all registered vessels, including, right, lots of cargo carriers and so forth. But we can see that in general, flag of convenience countries, and here are some of the kind of more notorious ones, Panama, Liberia, Marshall Islands, and on down the line, they register a very, very large percentage of ocean-going craft, including fishing vessels. Unless we think that, well, maybe this is sort of just a problem of a bygone era, we're getting a hold on this problem. Actually, at least if we look at the data from 55 through 2014, the problem is growing even more, right? So it's not a problem of the past. In fact, it's a problem of the present and the future. Okay, well, what about coastal states? Maybe coastal states are really sort of our answer then, or our big sort of solution to the IUU problem. Because you might say, well, hey, coastal states, they have the incentive to look after their waters and look after the fish within their waters, right? Maybe they depend on those, for national fisheries, for other things like tourism. And after all, within their EEZ, at least they have sovereign rights, according to UNCLOS, over those living marine resources. So they've got all the incentive in the world to protect those resources. That's the term that's used in UNCLOS, and prevent IUU fishing. Well, one problem, at least, is a lot of those countries do not have monitoring, surveillance, and control resources, at least not nearly as much as they need to deal with IUU fishing on a large scale. This map shows some IUU fishing incidences over a couple of decades. It's a little bit dated, but nevertheless, we can see that a lot of the hot spots for IUU fishing are in the global south. And a lot of these countries simply don't have robust coast guards and monitoring apparatuses. So it's a problem. They can't necessarily do it, even though they want to and have the incentive. Another sort of phenomenon that can compound the plight of coastal states is transshipment at sea. And we can see a few hotspots here of transshipment at sea scenarios. And this is basically where fishing vessels, right, which harvest or fish from the sea, pass their catch to a refrigerated fish carrier, which then goes to port. And it complicates enforcement and it complicates traceability because the boats can stay at sea for a really long time, the fishing vessels that is, and they don't necessarily have to go into port with the catch. Instead, the catch comes in mixed in with catches from a lot of different boats, and it's just much harder to say to a vessel in particular, hey, where did you get this fish? And we don't think this was legally sourced. And these hotspots also tend to occur, at least many of them, in areas with enforcement problems, enforcement shortfalls, monitoring and enforcement shortfalls. Okay, so, well, all right. In the high seas, at least, we've got these RFMOs. We've got these regional fisheries management organizations. So they can take care of IUU fishing, at least on the high seas, right? These are these multilateral organizations. They're creatures of treaty. They got it. They're on the case in the high seas. Well, yes, we don't mean to bad talk RFMOs. They play a critical role, but so first, let's just look at a couple of maps so we kind of know what we're talking about here. When people talk about RFMOs, frequently they're talking about tuna RFMOs. These are the larger ones that are more known, at least. Tuna and tuna-like species are kind of the big money species around the world for commercial fisheries. You can see we got them all around the world, basically. We also, though, have what are sometimes called general RFMOs. these are RFMOs that manage fisheries other than tuna. And here you have some more gaps in sort of geographical coverage, and you definitely have some gaps in terms of species coverage. Here's where you can see some unregulated fishing on the high seas, depending upon what the vessel's going after. You know, if it's going after, for instance, squid in the Indian Ocean, that's going to be unregulated fishing, at least vis-a-vis RFMO presence, because there's not an RFMO that manages that fishery in that part of the world. Okay, what do RFMOs do? I'm going to just try to make this super quick. This, you know, merits its own day of presentations probably, but they do a lot of different things. But one of the key functions is to manage a fishery, the fishery in question, to guarantee maximum sustainable yield. And they do that, or they try to do that, through setting total allowable catch, and then distributing quota as necessary or as appropriate. A couple things to note about this is maximum sustainable yield and total allowable catch are like they sound. In other words, RFMOs are not conservation organizations, or at least not conservation organizations pure and simple, right? They are designed to promote fishing activity. It's a sustainable fishing model, right? The idea is allow it as much as possible, but not more than what's possible to be sustainable. And that just is what it is, right? Okay. Well, RFMOs also try to sort of regulate fisheries activity to make sure those limits are respected, but then also sort of hedge against or control against IUU fishing and fishing practices that can be harmful to other species, you know, non-target species, and so forth. So they do this through conservation and management measures. Just going to rattle these off. We're not going to go into them. It gives you a flavor of what's going on with RFMOs. They have gear and technique rules. So for instance, use of fish aggregating devices may be severely restricted or outright banned. Observer coverage rules, you know, how many in-person live observers need to be used per number of vessels. Is there video observer coverage, things like that. Vessel monitoring system rules. This is basically a way to be able to track vessel positions for fisheries purposes. Catch reporting rules, go back to that whole unreported fishing idea. Transshipment at sea. Shark conservation measures. You can have fin to carcass ratio rules. You can have outright bans on retention of certain species, no finning at sea, things like that. And they also have IU vessel lists. Now, this is actually sort of one of the compliance forcing or enforcement tools that RFMOs have. If a certain vessel breaks RFMO rules, it can be placed on an IU vessel list, which means that it's not eligible to participate in that fishery. So there is something there. There is some teeth, right? The RFMOs do have some teeth. Excuse me. Last thought on this, and then I'm going to pass it to my colleague, is, RFMOs have a number of tools to control IUU fishing on the high seas. But as we've seen in other cases, thinking to coastal states, for instance, they don't always necessarily have all the resources. And because these are creatures of treaty, and these are multilateral organizations, they might not be able to respond as aggressively as a nation state can. RFMOs can't prosecute people and throw them in jail. They don't have that competency, right? So they can do a lot, but it's always, of course, within the confines of a treaty-based organization. So with that, I'm going to pass it over to my colleague, Erica.
Thanks, Nick, for that super informative introduction to IUU fishing and the role of RFMOs and sort of looking at some of the challenges. I think it bears a little bit of reflection here, having gone through all of that material, and some recognition of the idea that from an animal law perspective, so much about how we regulate and manage and interact with the oceans is highly imperfect, and is barely cognizable of the sort of animals' lives that are lost. Which is one reason why we tend to focus so much on IUU fishing, as such a key problem to address, is because, it is a concept, like a global legal concept, that if we're enforcing and, complying with the rules that exist, as Nick described, fewer animals are losing their lives. So what I want to transition to, as Nick is suggesting, is looking at how the US is addressing this. And to be clear, these are tools that we can use in US law, but again, it's coming very much from a human-centered perspective, in many ways, about sustaining fisheries. So I just want to acknowledge that. And then, and that said, for us all to think about as we talk through these mechanisms, their potential to be effective, and how the US, one thing that I think is really interesting about these tools is that the US, given its market share, in terms of imports of products from around the world, really has some might in dealing with and addressing some of these global challenges that are supranational in scale and character. Okay, so as we've mentioned, the US has taken steps through domestic law to improve the effectiveness of RFMOs, or as I have on these slides, IFMOs, International Fishery Management Organizations, which is how the US in general describes, it's sort of an RFMOs plus concept in US law, a little bit more inclusive of potentially other international agreements than just the concept of RFMOs. But what's notable here, the US law that is notable here, is the High Seas Drift Net Moratorium Protection Act and its many amendments that have built out this enabling environment for the US to support compliance and enforcement of these RFMOs and then other international or relevant international agreements, like a high seas drift net ban, for example. So in general, where nationals of a foreign nation are undermining the effectiveness or undertaking activities incompatible with these multilateral agreements to which the US is a party, the US can identify, certify, and then proceed to impose sanctions or, deny market access to specific goods from a specific country. You can see here that these mechanisms, as the US has established them, apply to sort of three different focus areas: IUU fishing, the bycatch of protected living marine resources, and then shark fishing in the high seas. And we will talk about all of those in a little bit more detail. So I think just a say and consider about the effectiveness of these mechanisms and how the US uses them, or maybe doesn't use them to their fullest extent, as well as really interesting, from a legal perspective, implications for international trade law, So all sorts of things we could talk about. I want to be clear that we have like a pretty narrow focus here. And this is not sort of a comprehensive review of all the law of these mechanisms. But sort of one underlying interesting factor in all of this, or sort of the unspoken element here, is that this is really, these mechanisms are all built on the idea of the US's diplomatic muscle, right? And it's this, the US sort of envisions that this diplomatic muscle exists as coinciding with the threat of diminished market access to the US, right? And so I think we need to keep that in mind, because as we're thinking about the potential for these mechanisms, there is a direct relationship with the target country and what the threat would be of losing port access or market share to the US. And this goes back to a point that Nick had identified, which is in regard to the sort of issue of flag states and, you know, the extent to which those, you know, different countries all over the world are really bringing fisheries products to the US. Okay, but with those reflections in mind, maybe we can, let's sort of break down these mechanisms to see if we can get a general understanding of them. So next slide, Nick. So in general, there are sort of these compliance tools that the law establishes all function similarly. It is essentially a three-step process comprising identification, certification, and then potential sanctions. As you can see here, identification really looks at it's a who, what, when, where analysis, which we're going to go over in more detail. But you can see that the identification criteria focuses largely on the type of activity, where the activity occurs, the species that might be subject to that activity, and then the timing of the activity, as well as to relevant legal contexts, including any potentially relevant RFMOs, and some issues as regards maybe US law, okay, which we'll talk about. And then, so once the US has identified these countries, nations that are either flagging vessels or, you know, behaving in such a way as they meet these identification criteria, NOAA Fisheries includes them in a biannual report to Congress and describes the concerns. At that point, there's a period in which, you know, the US engages directly with that country. It's a 2-year time period. So then at the next biannual report, after identification has occurred, the US, for each of those countries it has identified, certify the country positively or negatively. And so when the certification is positive, essentially the nation sort of falls out of the mechanism, right? It is indicative of the US and that particular country engaging in a way that you know, made the US feel comfortable as like the decision maker, that compliance, that there have been rectifications in terms of compliance and any regulatory norms that should have been imposed in order to be in compliance with RFMOs or really US law as regards how these mechanisms or what these mechanisms apply to. When negative certification occurs, the Moratorium Protection Act provides for certain punitive measures that are really intended to sort of have more of a strong arm corrective action. So you can see here, this includes denying port access to vessels, flying the flag of a nation that is subject to a negative certification, or import restrictions on fish or fish products from that nation. So used aggressively, in certain cases, major market shares and supply chains can take significant hits, which nations typically would want to avoid, right? So ultimately, it's the threat of these sanctions that it sort of enable the strong arm diplomacy that can occur at the certification within the sort of certification window. So before the US has made a decision as to whether to certify positively or negatively. Interestingly, despite of these really strong tools, IUU fishing problems are, well, in spite of these strong tools and their potential for ameliorating some of the IUU fishing problems faced globally, it's interesting to just reflect for a second. So in the last report to Congress of, a couple dozen nations that were identified, only 2 received negative certification. So there's 2 ways to see this, right? Either this is an incredibly effective mechanism, and the key is to identify all potential situations that meet the certain criteria. And that's where you sort of unlock the potential through strong public participation and robust analysis at the identification stage. Or in general, as we'll talk about, maybe the scope of what these programs actually, when you get down to the nitty-gritty, apply to is insufficient, or there are other, and this is probably true, as we all know, when dealing with international law, like other political calculations that go into identification and certification that sort of limit the power of these mechanisms. But with that, let's take a deeper dive into what's required for identification for each of these 3 mechanisms, as that's sort of where the game is played in terms of public access and how sort of lawyers advocating for animals might use these mechanisms. So if we go to the next slide, we can see here that this is just to sort of recap that there are these really 3 different mechanisms that overlap in some ways. There's a mechanism that applies to IUU fishing. There's a mechanism that applies to, on your slide, we say PLMR. It's an abbreviation or acronym for Protected Living Marine Resources, which we'll define in a future slide. And then shark catch. So again, each identification for each of these mechanisms is really this who, what, where, when analysis. So, and each of these target issues relies on a similar analysis. Next. So you can see here regarding the who and the when, these are the same across all 3 mechanisms, right? In general, we're looking at the actions of fishing vessels and or nations. The IUU fishing prong actually makes a nuanced, interesting distinction, or legally interesting distinction in this regard, where it suggests that the IUU fishing problem could be either a vessel's ongoing fishing in a way that undermines an RFMO or IFMO, or a nation's non-compliance with conservation and management measures, or the CMMs, as Nick described. Now, the distinction is probably mostly important for State Department lawyers, but it's interesting because it rests on this idea that states are the actors in international law, and it's a state, not a vessel, that is usually seen as violating international law, right? So in multilateral environmental agreements and bodies like RFMOs, adopted measures like CMMs will be directed at the state party to undertake a particular action, such as requiring vessel monitoring systems, as Nick suggested. A little bit of a diversion, but an interesting one from a legal perspective. So regarding the when, although there used to be some differences in the sort of look back period for the different mechanisms, now each mechanism really is based on activities that have occurred within 3 years prior to the reporting year. Where we start to see differences between the mechanisms are the what and where. So let's go through these one by one, or each mechanism one by one, and look at the sort of what and where aspects to see when they apply. So let's look a little bit more closely at how identification works and some of the factors that are taken into consideration under the IUU fishing prong first. So importantly, the statute sets out the basic scenarios that should result in identification, but the statute doesn't itself define IUU fishing. Instead, NOAA has defined IUU fishing via regulation, and the definition is really quite comprehensive. It's comprehensive, but with a very specific US focus, so that the definition is cabined not as broadly. It doesn't catch as many scenarios as Nick described earlier in his presentation, but really focuses on translating sort of those scenarios to make sure that there's a US interest at stake in how in the application of this mechanism and the scenarios that could result in identification. So the definition of IUU fishing is really the basis for assessing whether certain activities qualify for identification under this prong. And there are really sort of 5 scenarios envisioned there. 4 are circumscribed by sort of what constitutes a fishing activity as that's defined. And then there is an additional scenario that sort of escapes that definitional confine. So under the sort of rubric of fishing activities, and when a fishing activity is occurring, these 4 scenarios are as follows. The first are fishing activities that violate conservation or management measures of an RFMO or IFMO, rather, to which the US is a party. So you can see that limitation in that we're concerned mostly with IFMOs where the US is a party. The second is concern regarding fishing activities that undermine conservation management measures of an IFMO when the state is not a party to that IFMO or is not considered to have what's called cooperating status with that IFMO. So again, states that aren't party to a particular IFMO don't have the obligation to comply with the CMMs adopted by that IFMO. So here the US is trying to get at those states that may just evade joining or becoming a party to RFMOs in order to not be subject to sort of this RFMO CMM law that papers the ocean landscape. Okay, so next we have fishing activities that result in a significant adverse impact on certain marine ecosystems. which are elaborated a little bit further in the regulation and include things like coral reefs and thermal vents. But it's these ecosystems and fishing activities that occur in areas beyond national jurisdiction, or ABNJ, in short, the high seas. And then where no IFMO exists, so in those pockets that aren't covered by an RFMO, or where there aren't relevant conservation and management measures if there is an RFMO. Okay, and then lastly, this prong can apply to fishing activities, by foreign flagged vessels that are unauthorized to fish in US waters. So this is more of sort of your typical domestic law issue, right? Like you are a vessel flagged by a country, not the United States, and you don't have a permit to fish in our waters. That's IUU fishing for the purposes of this mechanism. Okay, and then next we have a scenario that the US envisions that is de-linked from the definition of fishing activities and instead describes overfishing. And here we're concerned about overfishing of stocks that are shared by the US, where the overfishing is occurring in areas without applicable conservation and management measures or international fishery management organizations. So you can see here the sort of interaction between the what and where factors in these analyses and how that really scopes the nations or fishing vessels that could be identified under this prong. Okay, so if we go to the next slide, let's do the same sort of look at the mechanism that applies to PLMRs, or again, protected living marine resources. So what we're concerned about here are fishing practices that result in the bycatch of a PLMR. So where the marine resource that we're targeting through this mechanism is not intentionally caught, but is the product of fishing for another species and perhaps entanglement, or hooking when using long lines, sort of other bycatch scenarios. Important here, if you click, Nick, is the definition of Pacific living marine resources. So the definition gives an interesting, it's a very interesting sort of legal definition and gives a very interesting scope to what constitutes a protected living marine resource. So we're talking about non-target fish, sea turtles, or marine mammals. So we have fish, turtles, and marine mammals that are protected under US law or international agreements, but not species, except sharks, that are managed under the Magnuson-Stevens Act or the Atlantic Tunas Convention Act or an IFMO. So it's complicated, the definition, in a lot of ways. I think what's frankly frustrating about it is that it is making a distinction between species and animals that are of conservation concern and are thus protected under US laws. And that would be US laws like the Endangered Species Act, the Shark Finning Prohibition Act, international agreements like the Convention on International Trade in Endangered Species. And so those species are in sort of one category, but then there are these other species that we are managing for the purpose of harvest and consumption. And, in order to, in this sort of, non-animal at the center driven perspective of US law, particularly where it comes to oceans, we carve out these species and say, we don't want to apply this mechanism to them. because we're less concerned about the bycatch of those species. Now, I think from a scientific perspective, maybe that doesn't even make sense, as, potentially bycatch of those species can cause problems when setting quotas, and other issues, but that's the way this prong is scoped. Interestingly, though, and important to keep in mind, is where this prong might circumscribe certain scenarios from, being able to enter the mechanisms or be identified under this prong. The IUU prong isn't scoped similarly. So it provides a backfill in a lot of the scenarios where, okay, so next we can look at where these activities occur and how where they occur either could result in identification or doesn't. So we're concerned about the bycatch of these species when it occurs in areas beyond national jurisdiction, or ABNJ, or beyond the US exclusive economic zone. So as Nick described, beyond the 200 nautical mile marker. And then interestingly, if you click again, Nick, the protected living marine resource prong and the shark catching prong sort of add additional elements to the identification analysis. The RFMO factors that you can see here are factors that are built into the IUU fishing definition. So we're looking at, areas where an IFMO has failed to adopt relevant CMMs, where a nation is not party to a particular IFMO, or, like I said, doesn't have cooperating status. And then if you click next again, Nick, there's this additional factor that applies here, and I call this the comparability factor. So this is where, in order to be identified, a nation must not have yet adopted a regulatory program governing fishing practices that reduce bycatch that is comparable to the US. So there's this comparability factor. This factor, when NOAA is analyzing this factor, it will take into account different conditions, different circumstances. And like I mentioned briefly when we talked about sanctions, there's jurisprudence from the WTO and further elaboration of factors considered by NOAA under US law that give a fuller understanding of what this means. But it's important to know that it's a factor. Next. So next, if we look at the shark catch prong, the what here, we're looking at fishing activities or practices that either target sharks or incidentally catch sharks. So both the sort of bycatch scenario as well as targeted fisheries. But here the where factor is more limiting than in some of the other circumstances. So here specifically, we're looking at when these activities occur in areas beyond national jurisdiction. And again, there's a comparability factor that is similar to the factor considered under the protected living marine resources mechanism. So that gives you a sense of the sort of factors used in identifying nations in this biannual report to Congress, which if nations over the next 2-year time period are certified negatively, can be subject to either port access denials or sort of market access denials. And in many circumstances, right, that's a really powerful motivator to ensure maybe not to ensure compliance, but to motivate regulatory changes or enforcement actions in these scenarios that the US has identified as problematic. So a potentially really strong tool, and I think a mechanism that the US has an interest in promoting internationally as an option for addressing the IUU fishing issue. So with that, I'm going to pass it back to Nick to talk a little bit more about some of the international efforts.
Thanks, Erica. And this is sort of our last substantive piece of the presentation. And we're going to talk about another set of actors, really, or category of actors, and some of the recent work around sort of leveraging the potential power of these actors. And here we're talking about port states. So the key here is to keep in mind, we have this, in most instances, transnational supply chain. And like the name sounds, a supply chain has many links. One of those links is the port link, or the landing link. And basically, we have a little graphic here, which kind of outlines the major steps in the commercial fisheries supply chain. Of course, first we have harvesting, then we have landing, right, which I just mentioned, processing, distribution, retail and food services, right? So your supermarkets and your restaurants that serve fish and fish products, and then finally, of course, your final end consumer. What's interesting about all this, and why we recognize that port states have potentially so much of a role to play, or so strong of a role to play, is the following. No matter what, right, fish have to get to market, and to get to market, they have to be landed. So, with marine fisheries, it's kind of an all roads or all sea lanes lead to ports scenario. And what's interesting about that, and what makes the port part of the supply chain particularly ripe for policy and enforcement intervention, frankly, is this sort of natural bottleneck effect. So the way that you want to think of this is sort of, you've got disperse activity, right? Then you've got tight bottleneck, and then you've got disperse activity again. So disperse activity on the front end being all the fishing activity that's happening in the ocean, right? That's very dispersed in terms of both time and place. Difficult to monitor and control because it's all over the place, right? And also varied over time. On the other end of this bottleneck, right, once products go out into sort of consumer land within a given nation, it's also pretty dispersed or diffuse at that point as well. But the bottleneck is at the port, right? That's when the fish comes in, and it's relatively concentrated, and there's a great enforcement opportunity. And I should be careful when I use the word enforcement, not just enforcement, but also monitoring and control opportunity, right? That's the place to really make sure, hey, is anything that's coming in, of illegal or IUU provenance? Well, here's our opportunity, our best opportunity in a world of scarce resources to check, right? And if something's afoul, maybe take some kind of action. So the global community has recognized this, right? And in a pretty interesting development, we have a new treaty, relatively new treaty, under the auspices of the FAO, the Food and Agriculture Organization, called the Port State Measures Agreement. And what's interesting about this treaty, and it's actually in the name, the full name is the Port State Measures Agreement I'm going to miss some of the verbs. It's not to control or to combat IUU fishing, but my point is IUU fishing is in the name of the treaty. And it's the first treaty of ostensibly or potentially global scope that is directly focused on IUU fishing. We've had soft law instruments, right, that are very important, like the FAO's IPOA on IUU fishing, International Plan of Action on IUU fishing. We have related even earlier instruments like the FAO Code of Conduct, but those are soft law instruments. Here we've got a treaty. And as I'll show here later, after explaining the kind of heart of the mechanism within the treaty, it's picking up a lot of state parties. It went into force in 2016, and it's picking up parties pretty quickly. So how's it work? What's the why is this worth talking about? Well, again, it tries to leverage this natural bottleneck, and states that are party to the Port State Measures Agreement have a few different obligations. So one of those obligations, kind of a key that sets everything else up, is to designate certain ports for foreign fishing vessels, and the term vessel in this case is actually defined broadly to include refrigerated fish carriers. So not just the boat that puts the lines in the water, but also refrigerated fish carriers. So foreign vessels that come into port, the states that are party to this treaty have to designate certain ports for those vessels. Now, it is important to note, just as a bit of a limitation, I suppose, it only applies here to foreign fishing vessels, right? So vessels that are flying the flag of the state party can ramp up even more that bottleneck effect, right? Let's say, a country has 10 major ports. Well, they designate 2 of them to receive foreign flagged fishing vessels. The bottleneck effect and the ability to control and monitor fishing vessels and what they're bringing in is ramped up even more. Okay, so designated ports. And then what do you do with those designated ports? Well, this is the heart of the treaty. So basically, if a country that's a party to this treaty has information showing that a vessel in question has engaged in IUU fishing, right? And the definition, I should say, of IUU fishing in this treaty essentially mirrors the one we outlined at the beginning under the FAO IPOA on IUU fishing. So, okay, port state that's a party has information showing that that vessel's engaged in IUU fishing. What can it do? Well, what it's supposed to do usually is to just deny port services. So what that means is that boat can't come in to land fish. That boat can't come in to receive maintenance. It can't come in to refuel. It can't come in to load up on food. There's an exception for force majeure, but basically the idea is, well, if you've engaged in IUU fishing, we don't want you using our port. And the beauty of this is, if you get enough countries, right, to sign this, to adopt and become parties to this treaty, now all of a sudden you've eliminated ports, and without ports, IUU fishing is dead in the water. Pardon the pun. And yes, we're probably never going to get to a place where every single state is a party to this treaty, but you can really shut down entire regions and really drive up costs as well, because, okay, maybe there still are some ports or ports of convenience, but it's more costly to get there. You got to go farther. It's a longer, it stretches out the supply chain. And obviously, anytime you increase the cost of a dirty business, you're going to help to put some of that out of business. So that's kind of the idea. Now, there's another option. What if, all right, maybe there's some IUU fishing going on, in this vessel's recent past, but we're not sure. We're really not sure. And we don't want to just sort of say, oh, you can't come to port, because maybe we're wrong, right? Maybe there's some tip, we've received a tip, but we really need to confirm it. We're not sure. Well, there's an option that speaks to that scenario. The vessel can come in to the designated port, but for purposes of an inspection, right? To confirm or dispel the suspicion. And so, again, the basic point is take advantage of this natural bottleneck. Recognize that if vessels can't land, their ill-gotten product, then they really can't continue in that business, or it's going to be much more costly. Either way, you're putting a lot of pressure on the global IUU phenomenon. And here, just to end, is a map. This is the most recent kind of picture of states that are parties to the Port State Measures Agreement. And you can see, yeah, there's still a lot of gray. Those are non-parties. But we're honestly, for a pretty young treaty, they're picking up states pretty quickly, and we're starting to see regions, in particular, that are starting to become very IUU antagonistic, right? Most of the western coast of South America is on board, and so we'll start to see some of these gray areas fill in, and it's a great trend. We're going to wrap up and say goodbye to everyone, thanking you, of course, for your attention, for your interest in this topic. We hope you learned something, and thanks again for giving us the opportunity to share some of these insights with you.